The wills and estates work in many ways goes hand in hand with the general type practice that I have. And by that I mean every single person, as far as I'm concerned, as soon as they own a sizable asset, whether it be their first home, their first car, or they have a child, or they get married, needs, not should, but in my opinion needs to have a will and power of attorney done. The things you need to think about is who you'd like your estate trustee to be. That's obviously crucially important because that's the person or persons who will be handling the dissemination of your assets, and by that I mean the person who will be dealing with the process once you've passed away. You need to get the will probated, and by that it means that it has to be certified by the federal court here in Ontario and in Canada. Once it's been certified and the executor has done their job, then you can distribute the assets pursuant to the will. With respect to the power of attorney, that is the document that deals with issues that will or could arise if you end up in a position where you're not able to handle your own affairs. So you end up in the hospital, you end up, maybe disabled in some way. And so I always recommend to get my clients to get a power of attorney for both personal care as well as property, so that if they need bills paid, somebody can go, to the bank to get that taken care of. And if there are certain crucial medical and medical decisions that need to be made, those can be done as well. As a corollary to the power of attorney, I do recommend to my clients to get something called a living will taken care of as well. That's also coined as a DNR, or do not resuscitate document, and that's the thing that deals with all the moral and ethical decisions that might need to be made if you're in a position of being incapacitated. So here we try and sort of take the sting out of dealing with the mortality that comes along with dealing with a will, a power of attorney, and living will. By making the process simple. We have a worksheet that we put together for our clients that they can fill out. We go through the process, and my motto here, no matter the area of law I practice in, is to try and make it as simple and easy as possible for clients, to ensure that when they leave here, they have a full understanding of just exactly what they've had taken care of. So, again, I strongly urge to my clients to get a will and power of attorney and a living will taken care of as soon as possible, as opposed to sitting and waiting on it. It's relatively cost effective, all things considered, and it's that ounce of security that you're otherwise not going to have. And when you die without a will, you die they call it intestate. And not that it's an overwhelming process, and it doesn't mean that all your assets are going to go to the state automatically, but you're leaving a real mess for everybody left behind. And we all know nobody wants to do that for their loved ones. So it's prudent, it's effective, and it's a manner that, in doing so, you can at least rest easy that once you've passed on, there's no issues, and God forbid something happens again, at least somebody is in a position to make sure that your affairs are taken care of.